Viewers, in a significant development that constitutes a reprieve, albeit interim, for all Hindus who have been protesting state control of Hindu religious places, the Karnataka High Court has stayed the complete takeover by the state government of the Chamundeshwari temple dedicated to the family deity of the erstwhile Mysore royal family. Viewers, this is a big story. This is a big story because it has implications. And that's why we're leading with it here on the hard facts tonight. The relief from the High Court will at least temporarily still the hand of the Karnataka government that was happy to blur the lines between religion and state to wrest control of the temple by passing a law earlier this year. Viewers may be aware that Hindus are discriminated under the law that denies only them the right to manage their places of worship across several states of the Indian Union. So this is not a Karnataka-specific problem, viewers. The Chamundeshwari Kshetra Development Authority Act 2024 was passed by the Assembly in Karnataka in February earlier this year. The act was passed not long after a member of the royal family was tipped to be a BJP candidate for the Lok Sabha polls. That person eventually went on to win the election. The act to establish an authority to develop and maintain Sri Chamundeshwari temple in Mysore, the temple complex, was to be turned into an international pilgrim, cultural and tourist center. The owners of the temple had accused the state government of blurring the lines between religion and state by pursuing the takeover of the Chamundeshwari temple. That the Congress embarked upon this expedition is unsurprising, viewers, given its own two-faced approach in the past to secularism. But that is not the subject of the story. Let me talk you through the initial reasons why the Hindu owners of the temple opposed the Karnataka government's move. Pramoda Devi Wadiyar, erstwhile Mysore royal family member, came out and said, while the case is pending, it is not right for the government to establish an authority. They can regulate, but they cannot own. As a secular government, they should not own religious institutions. Their attempts to take control of both movable and immovable properties is unacceptable, unquote. That's what she said, viewers. And this sentiment is echoed by millions and millions of Hindus, including the man in the middle of your screens, Mr. Sadhguru. Viewers, Sadhguru has been campaigning in the south of the country and elsewhere, calling upon the state to relinquish control of Hindu places of worship. Remember, the state only controls Hindu places of worship in their entirety. The erstwhile royal family of Mysore, in its plea, invoked the rights under the Indian Constitution to make a case out against the Karnataka government's law. They invoked Article 13, where the state shall not make any law which takes away or abridges fundamental rights. Article 25 entitles you to freely profess, practice and propagate religion. Viewers, Article 25, if it guarantees that, then what is the state doing? Monitoring, controlling the profession, the practice and the propagation of a religion, viewers. Article 26, every religion has the right to manage its own affairs in the matter of religion. So how come, viewers, that the Hindu faith is deprived of this right? For now, the High Court has restrained the state government, but has also added some caveats. Pending dismissal of writ petition, Chamundeshwari temple cannot be overtaken by the state. That is what the High Court has ruled. No immovable or movable property of the temple shall be disposed of. Very clear instructions. No customs or traditions of the temple shall be modified, and government has been restrained, the state government that is, from taking any action without the prior permission of the High Court. Now, viewers, as I told you, is this fight for Hindu rights now beginning to slowly turn a corner, or is this, in legal parlance, some sort of an exception? Let's ask fundamentally some of the stakeholders. J Sai Deepak, advocate who has been leading this battle. J Sai Deepak, first explain to our viewers what is the context of this litigation.
So let me first clarify my own role in this. I play no role in the movement in the capacity of, let's say, a rights advocate. My participation is primarily in the capacity of a litigator, because that's the only way you retain a professional approach to the course of action or the legal strategy. Uh, I've been engaged in this litigation by the Mysore royal family as their arguing counsel before the Karnataka High Court. So I'm not the counsel on record. I'm not the one who's filed the petition. I'm the one who argued the matter. So this is more in the role of a barrister. So just to give a crude example. Now, as far as the context is concerned, the Chamundeshwari temple enjoys the same relationship with the Mysore royal family as the Padmanabha Swami temple does with the Travancore royal family, just as the Eklingji temple enjoys with the Mewar family, just as the Jagannath temple enjoys with the Gajapati of Odisha, just as temples in Cochin enjoy with the Cochin royal family. So across the country, you have several such examples, just as for that matter, the Kashi royal family enjoys with the Kashi temple, for that matter, the Vishwanath Mandir. Okay. Now, this is important because when each of these princely states acceded to become a part of the Indian Union, the royal families, as part of what we call the covenant of mergers, rights and mergers, basically decided to carve out for themselves those properties which shall not become part of the union's property upon accession. Okay. So one is the accession instrument, and then is the covenant, which follows the accession instrument, in which they basically say these are private properties which shall not be touched upon by the union. So the Privy Purse's establishment was also as part of this very agreement, and subsequently it was abolished by the 26th Amendment. Okay. Now, therefore, the Chamundeshwari temple specifically forms part of entry 62 of the covenant between the Indian Union and the Mysore princely state. Therefore, the Indian state, for that matter, whether it's the state government or the central government, will continue to be bound by that particular accession agreement as well as the covenant of mergers. Okay. Let me just clarify here. I am not going to make legal submissions. I will make only factual statements because the matter is this.
Naturally,
right?
yes.
Now, in 1957, the Karnataka government, the then Karnataka government, comes out with a GO delisting this property from the list of private properties of the Mysore family. Okay. Then in 1974, they take over this particular legislation under the then prevalent HRC Act. Rather, they take over this temple under the then prevalent HRC legislation. That is the Hindu Religious and Charitable Endowment legislation. In 1998, that is from 1985 onwards and even before, the family has been challenging each of these GOs. Now, this entire litigation continues to be pending before a division bench of the Karnataka High Court. So there is a specific writ appeal that is pending because the original writ petition that was filed by the Mysore royal family challenging the delisting of this temple as a private property and the takeover of this temple, both of them were filed, or both of them were challenged in a writ petition. That writ petition got dismissed by the Karnataka High Court, and subsequently it's been challenged in an appeal before a division bench. Now, this appeal has been pending since 2001. Okay, in the sense it is yet to be taken up for final arguments.
Over 2001?
Yes.
That's a huge amount of time.
For 23 years, it's been pending. I don't know what it says, but effectively that is the status of pendency here. Now, the problem is, since it's been pending for the last 23 years, over the last 2 years, what has happened? Successive state governments of Karnataka have decided that they will start some winch and rope project in the Chamundi Hills, which is already an eco-sensitive area. And they've decided to take up all sorts of so-called developmental measures. Under the garb of this particular development measure, they were trying to change the character of the temple and the hill itself, because the hill itself is treated as a sacred spot. Just as Ram Janmabhoomi, apart from Ram Mandir, is treated as a sacred spot, the Chamundi Hill itself is sacred. So if you go to Kamakhya Mandir in Assam, the Nilachal Parvat over which the temple sits, the Nilachal Parvat itself is seen as a sacred spot. In fact, it is seen as a deification or as a personification of the deity Bhairava. Okay. So therefore, there were serious concerns about these so-called developmental activities. And therefore, over the last 1 year, we have been constantly requesting and urging the division bench of the Karnataka High Court to put an end to these repeated encroachments, because while the question of ownership is still pending before the division bench of the Karnataka High Court, they can't undertake these activities because that changes the character of the property.
Yes.
Think of it as a property dispute. The ownership of your property is in question before the court, while the usurper continues to change the character of the property.
No, I can't understand this. There is a contradiction here because there is a Places of Worship Act which till now forbade anyone to even determine the character of a place of
I'm
worship.
not saying the religious character, but what it does is that in the name of beautification, a lot of activities are undertaken, which has altered seriously the ecological balance and also the, let's call it, it has only endangered the already fragile place that has happened. Then there are quite a few heritage structures, and those heritage structures have suffered as a consequence of poor upkeep. Now, anyways, coming to the point, while this has been going on, out of the blue, this year, the government chooses to pass a legislation that takes over the entire ownership and management of the temple and vests it in the authority created by the government, which effectively operates as an arm of the state government. This is called the Chamundeshwari Kshetra Development Authority Act of 2024.
Yeah.
So litigation is pending before the High Court. And while the litigation is pending, a legislation is passed which vests ownership in the state government of Karnataka. Therefore, we said, how can this happen? How can the legislature rule on a particular subject which is already sub judice before the High Court at this stage?
So obviously, I don't want to go into any of the political background because we know that the Vodia's family is sort of now associated with the BJP, and I don't want to go down that route. That might be a reason. I don't know, viewers, but certainly.
I am not approaching it politically. This is constitutional.
Exactly. So we are looking at it constitutionally. Now, what I have to ask you, Mr. J Sai Deepak, is the state is secular. So how does it justify passing a law that brings it into the ambit of managing the Hindu places of worship and their customs, specifically in a matter such as this?
So the justification that's been offered is that since the central government has come out with a prasadam scheme, which is meant for development of all, let's say, punya kshetras or holy spaces, they are saying that for the purposes of beautification and development, we must take over the temple. So we are seeing which development and beautification activity requires you to take over the temple completely, and is that not at loggerheads with your profession of so-called secular values? And in any case, you are welcome to undertake activities of maintenance, but why should you interfere with the religious activities? And what is your interest in the financial proceeds of the temple? What is your business actually stepping into the picture? So there is one question of stepping into the territory of any temple, but this is a private temple, which is the property of the royal family, guaranteed under a specific entry with the union. Okay. Therefore, our entire position has been, at the very least, no such legislation could have been passed while the matter is still sub judice. That's the first issue. Then the second issue is the impact of the legislation and its provisions on the rights of the royal family with respect to the temple, its religious aspects and its financial aspects, because it's private property. It is not the business of the government to step into it at all.
So I just want to ask you a couple of questions, J Sai Deepak. Does this extend to other faiths also? And supposing this law remains standing, then arbitrarily governments can, in other states, also extend this to Hindu religious places by saying that, look, we have to get in here because, you know, this, that, the other, beautification and all sorts of other practices. This is dangerous, some would say.
Fortunately, the interim order that's been granted by the Karnataka High Court yesterday effectively prevents the state government from alienating any movable assets, immobile assets, or any property that is associated with the temple in any manner. It prevents the state government from altering the existing established customs and traditions and usages of the temple. It prevents them from taking a decision without taking the leave of the court. Because what they've done is that there is an authority that is appointed under this particular act.
Yeah.
The chairperson of the authority is the chief minister of the Karnataka state government. And the member of the royal family is given just a permanent membership. If there is a difference of opinion between the members of the authority, guess who takes the final decision? The state government takes the final decision. So the state government apparently will take a decision that is contrary to the decision of the chairperson of the authority, who happens to be the chief minister of the state. We are being told that Caesar's wife will take a decision different from Caesar himself. Okay. So these are the kind of provisions. Fortunately, there were concessions made on behalf of the state government to be fair to them. and therefore a consent interim order has been passed, and the matter is scheduled for final arguments in November. For now, their activities have come to a grinding halt, which have the effect of altering the rights and status quo.
So, does this sort of approach apply to also other faiths and their places of worship, or was it only sort of directed towards one?
I haven't seen a single legislation that takes over any non-Hindu place of worship under the name of beautification and development. That's one. Two, if this path were to be acceptable, then every state government will take over every temple that it sees as a port of revenue under the garb of beautification and development.
Yeah. So that brings me to the question that one should ask at this moment. If such laws sort of are patently at some level or the other ultra virus of some of the provisions that have been cited by the petitioner here in their plaint, how have they survived so long on the books? And what does this tell us really about the mindset?
Right. So it's a petition, not a plaint, because a plaint is in a civil proceeding, but that's fine. The point is this. The bulk of these legislations are already under challenge, as you know, before the Supreme Court. Okay. While somehow the Supreme Court has not had the time to take up these matters since 2009, for the first time, a state high court has taken a clear decision, at least prima facie at an interim stage, to prevent this kind of interference. Okay. See, the point is this. As a litigator, I can happily say all of us must go to court with respect to each of these legislations.
Yeah.
Now, the point is then you will have multiple parallel litigations going on in different courts, and God knows when each of them will attain fruition or conclusion, right? Which is why I've been saying over and over again, the simplest thing to do is that the subject matter of temples and endowments and charitable institutions falls under the concurrent list, entry 28 of the concurrent list, okay? Which means it is available to the union government to pass a model legislation that secures three different aspects. One, the religious aspects of the temple, ensuring that there is no discrimination on the basis of untouchability, which already is guaranteed by the Constitution, while preserving the traditions of the temple. Three, ensuring that the property of Hindu religious institutions are used exclusively for the benefit of the community. Four, political interference must be limited fully, and the only power that the state must have must be with respect to supervision of accounts, but not create manufactured and motivated excuses to step into the institution to take it over forever. Okay? This is a very simple, straightforward issue. Those who are interested will take it up. Otherwise, what will happen is that people will ultimately say that lawyers will benefit, but litigants in the community will not. And I say this as a litigator. Okay? So there is an easier way forward, provided people who are interested and people in power are interested in acting on this particular issue. Otherwise, mischievous governments will use the very same beautification schemes which have come out for a good intention for these purposes.
Yes.
The Prasadam scheme produced by the central government was for the purposes of cleanliness, maintenance of temples and places surrounding it, not for facilitate police takeover or marching powers in the hands of the state.
Well, J Sai Deepak, congratulations to you, interim congratulations to you if there is something like that, because this is going to be a long and tough battle, but I hope you win it at the end of the day for all the sake of Hindus, because viewers, legislations like this get a life on their own, as you know, and they set precedents which, as you can see, then impinge upon the rights of the Hindu community. So viewers, thank you for watching this interaction with J Sai Deepak. Very significant. Thank you very much, J Sai Deepak, for joining me. Let's move on, viewers, because there's a lot that's been happening with regards to India.